I'm Jake Shurko. I'm a fellow here at the Center for Law and the Biosciences, and it is my great pleasure to introduce our next three panelists. We have Andrew Torrance, who's a professor of law at University of Kansas, and his interests range from design patents, which are something that I hope that many of you have never heard of, all the way to de-extinction. We have Alex Camacho, who's a professor of law at University of California, Irvine, who's a renowned scholar in some of the legal issues concerning environmental law. And we also have Chuck Bonham, who's the director of the California Department of Fish and Wildlife. I really want to commend Chuck for coming here today. It's very difficult sometimes to come to these conferences and speak, especially on record and with the title of being a director of a state bureaucratic organization, especially for things that are new and in some cases controversial. So thank you very much, and it is my pleasure to welcome Andrew to the forum. Thanks, Andrew.
Thanks, Jake. Okay, well, thank you very much to Hank and the others who've organized this. It's a real honor to do this, not only because the subject is fascinating, but also because this is the first time in my career that my children have ever paid any attention whatsoever to what I study. For 7 years, I've labored in the coal mines of the law, and my kids have no idea what I do. De-extinction, suddenly it captured their attention. So I'm going to talk about international law and genetically modified organisms regulation as it applies to de-extinction. And I want to warn you ahead of time that there's a tremendous amount of stuff I could talk about. I've left a lot of it on the cutting room floor, but I'll do my best to cover in a whirlwind tour what I think are the most important current frameworks that might apply to de-extinction. So first of all, I'm going to talk about a couple of what I call definitional conundrums. Are de-extinct organisms GMOs? Are they invasive species? These have implications for international law and GM regulation. I'm going to talk about the Convention on Biological Diversity and also the Cartagena Protocol there too. I'm going to talk about the CITES Convention, phytosanitation rules, including as they relate to the WTO, and then migratory species rules. I'm going to talk about de-extinction and GMO regulation, which has generally been a piecemeal approach in the US. It often focuses on commercial products for obvious legal reasons, and it actually sees action at the federal, state, and local levels, which is interesting. The potential legal frameworks out there already exist to deal with de-extinction. They're not complete. They may not even be good, but they often focus on things like commerciality, safety, especially human safety, sometimes environmental safety, and more broadly environmental effects, and then sometimes animal welfare. These are subjects that I believe other speakers today will speak on much more eloquently. There are few solid precedents for obvious reasons. This is a brand new phenomenon, and path dependence seems to me to be very important. Defining how the law ought to treat this ahead of time seems to me an important question, an important project for those who are contemplating and engaged in de-extinction. So first of all, are de-extinct organisms, or will they be genetically modified organisms? If the answer is no, the law is pretty quiet about how to approach them. If the answer is yes, then the law has some general and also some very specific regulatory approaches. You can imagine a continuum of genetic modification. The previous speaker sort of spoke about this, from thoroughly modified to not modified whatsoever. There's also the issue of product versus process. Even if an organism is not modified in its final form, how it's produced is often salient to people who are thinking about regulation. The US has tended to opt for the product approach rather than the process approach. Other countries, it flips. So I want to start with a little bit of Shakespeare. King Henry IV, Part 1. I'll find him where he sleeps, and in his ear I'll holler, Mortimer. Nay, I'll have a starling, shall be taught to speak nothing but Mortimer. Why is this relevant? Because naturalization societies thrived in the 19th century. Even today in New Zealand, there are naturalization societies. In some ways, you might think of de-extincting organisms as naturalization societies. There may be lessons to learn from this. Central Park was the home of introductions of species that are found in Shakespeare. Only the starling, I think, really became nationwide. But these organizations were trying to take organisms from other places and make them native in North America or New Zealand, Australia, etc. There is law on the books in the US that has to do with invasive species. I won't concentrate on the domestic side, but invasive species law is very important from the international side because organisms travel across borders. The Convention on Biological Diversity is a good place to start, I think. 1992 opened for signature, 93 entered into force. The US is not a member of the CBD, but almost every other country in the world is. Two protocols have come out of this, one of which I think is especially important to de-extinction, which is the Cartagena Protocol. It's been criticized as ineffectual, and extinction rates under its watch have continued to rise. However, within the CBD, there's some interesting sentiments. There were three goals: conservation of biological diversity, sustainable use of its components, and fair and equitable sharing. I think 1 and 3 are especially salient to de-extinction. 1, if this is a way of conserving biological diversity or even super conserving it by bringing components back, that is in line with number 1. Number 3, fair and equitable sharing. If technologies arise whereby richer Western countries can de-extinct critters, Part 3 of the goals of the CBD suggests that we ought to share that technology with other countries who wish to do similar things. Article 9 is especially salient, I think. It says that parties shall adopt measures for the recovery and rehabilitation of threatened species and for their reintroduction into their natural habitats under appropriate conditions. So the CBD, although it wasn't contemplating de-extinction, I think one, especially a lawyer, could insert into this the spirit of bringing organisms back and reintroducing them. Articles 15 to 21 are also sort of relevant. Countries are thought to have sovereignty over their genetic resources. That may include de-extinct creatures wherever they are brought out of extinction. Access and transfer of technology is considered important, especially from the rich to the poor. Information sharing, research cooperation, and benefit sharing figure prominently in 17 to 19. And then financing, again, usually from the wealthy to the poor in Articles 20 and 21. The Biosafety Protocol was the first piece of concrete law to come out of the CBD. Adopted in 2000, entered into force in 2003. Not surprisingly, the US is not a member. It adopted a precautionary principle towards regulation and especially trade in genetically modified organisms. And it's aimed specifically at transboundary movements of living modified organisms. The objective is to contribute to ensuring an adequate level of protection in the field of the safe transfer, handling, and use of living modified organisms resulting from modern biotechnology, with a focus on potential adverse effects and then on conservation and sustainable use. Articles 7 and 8 ask for advance informed agreement and notification before living modified organisms travel across borders. Article 15 and 16 require risk assessment and management. 17 deals with unintentional transboundary movements, something that could certainly happen if de-extinct organisms are released in one country and cross borders. And Article 25 talks about illegal transboundary movements and what the reparations should be for that. International Plant Protection Convention deals with preventing the spread of pests of plants and plant products. A pest is very broadly defined as any species, strain, or biotype of plant, animal, or pathogenic agent injurious to plants or plant products. Interestingly, the phytosanitary measures in this and some other treaties and law are contemplated explicitly by the World Trade Organization, and the World Trade Organization recognizes this as a possibly acceptable barrier to trade. So de-extinct organisms could qualify as a pest under this. Migratory organisms figure strongly in a number of treaties. There's a General Convention on Conservation of Migratory Species of Wild Animals. It protects wild animals that migrate. Again, de-extinct organisms could certainly do this. There's also, within the US, the template for migratory treaties, which was concluded in 1918 between the US and Britain, that is Canada later. And similar treaties concluded with Mexico, Japan, and the Soviet Union. And again, this has provided the template for migratory treaties since then. It forbids the pursuing, hunting, taking, capturing, etc. of listed migratory birds or their parts, interestingly, whether live or dead. So again, I think de-extinct organisms could be inserted in a lawyerly way into this treaty and treaties like this that contemplate both living and dead parts and organisms. It trumps state laws, which is interesting, and it could apply to things like the passenger pigeon and the Eskimo curlew, which, if de-extincted, could possibly become migratory again, providing they adapt well to the world. The International Convention for the Regulation of Whaling established the International Whaling Convention to regulate whaling, interestingly, not for conservation purposes, for commercial purposes. The idea is to keep the stocks healthy so that countries could harvest the maximum sustainable yield of whales. Didn't work very well for long periods of time, and then it flipped to the other side where almost no whaling was allowed, and engendered protest by countries that thought they had joined a sustainable yield convention rather than a conservation convention. Atlantic gray whales might be a candidate for de-extincting. They've been extinct since 1700, and there's some nice law under the International Convention for Regulation of Whaling which would seem to support the bringing back of stocks, including perhaps dead ones. Now, let's switch to GMOs. What does genetic modification mean? Is it a high-fidelity original organism, but reintroduced in secondarily non-native habitat? Is it hybrids? Is it slightly engineered? Is it massively engineered? And again, there's the issue of products versus process. The US focuses more on products. Other countries often focus on the process by which organisms are made. US GMO regulation is really quite messy. Since 1986, there's been the Coordinated Framework for Regulation of Biotechnology, which had 3 principles which were to guide agency actions. Focus on the product, not the process. Regulation should be based on verifiable scientific risks, a fairly high bar. And GM products are regulable, according to this framework, under existing statutes. No need necessarily for new statutes. Let's rely on the law that we have. The current regulatory approach remains piecemeal. And an example, GM crops. The FDA provides voluntary pre-market consultations on safety if this is going to be something consumed by humans or animals. APHIS licenses field tests of GM crops prior to commercial release. And the EPA registers pesticides, including those engineered directly into plants, such as BT engineered crops. Attitudes towards biotechnology differ greatly between the US and other countries. The US tends to be more permissive than most other countries in the world. Now, state GMO regulations. The foci tend to be on things like bans. For example, Boulder's Parks and Open Space Advisory Committee voted to phase out any planting of GM crops in the county's open space. Food labeling. New York currently is thinking about a GM food labeling statute. And then zoning. Monterey County zones genetic engineering activities. There's common law as well. Tort is going to figure prominently, I imagine, in the day's discussions, including whether or not de-extinct organisms ought to be treated under strict liability rather than negligence or a lower standard. And then also older concepts of nuisance might apply. And again, there's tensions between federal and non-federal power here, as there is so often in regulating anything. I want to suggest in closing a sort of a model that might be useful. I call it the ASILOMAR model. Self-regulation followed the 1975 ASILOMAR conference of genetic engineers. It was a relatively successful model. It anticipated and, in some sense, cut off at the pass federal regulation that might have been stricter. Much federal oversight today remains through funding rather than through direct prohibitions. A couple of caveats. Containment runs counter to some de-extinction rationale. So containment was one of the principles of ASILOMAR. Hard to know how you would successfully contain organisms that are de-extinct forever. May need to mask the risk of release against the risk of harm, and the risk of de-extinct organisms may often be low, so these principles may actually be too high for de-extinction. Synthetic biology has gone through a sort of example of this. They've tried to regulate themselves. There have been competing international rubrics for how to deal with synthetic biology and synthetic sequences. They've had a varying degree of success, and ultimately, the US government stepped in and issued guidance which appeared to sweep the field, despite the attempt of the industry to self-regulate. So that's a possible outcome for de-extinction, unless those involved in de-extinction come up with the kind of successful ASILOMAR model that appears to have prevented extremely strict federal or other regulation. I mentioned Starlink. Starlink involved a controversy where genetically modified corn, pollen was released into fields of non-GMO corn. This caused a big fuss. It ended up in people's tacos. And the public got very exercised about this. I think part of what this depends on is whether de-extinct organisms are returning to their original habitats, or whether we and the public think they're returning to habitats different from what they're used to, so whether they seem to be foreign and exotic or not. And in general, how the public is going to perceive them. And again, I think that's part of the job of those who are pushing de-extinction, to get ahead of public opinion and capture these issues quickly. Finally, the Europeans have a different approach towards genetically modified organisms, a stricter approach, many would argue. For example, in one of their directives, living organisms, whether released into the environment, large or small amounts for experimental purposes or as commercial products, may reproduce in the environment and cross national frontiers, thereby affecting member states. Release should occur step by step with carefully calibrated containment measures. That might actually be applicable to de-extinct organisms. Interestingly, member states in the EU seem to thumb their nose often at directives. There may be an EU level law, but at the local or the national level, countries often don't follow it. So in conclusion, definitional issues, I think, are significant, not just in international law and GM regulation, but I think in general. International law has several existing frameworks. Now, these are often in tension. Some push against de-extinction, you might think, and some actually promote de-extinction. So the conservation ideals push for it, I think, in some circumstances, and in other ways they push against things like genetic modification. Regulation of GMOs provides a different framework. The US and other countries differ in the way they regulate GMOs. The US, I suspect, is likely to chart its own course, as it often does in environmental law and biotechnology law. Law, I'd like to suggest, is as adaptable as biology, so I think those in favor of de-extinction should try and start to mold the law in a way that furthers their goals in safe and popular ways. And I just want to point out, at least with respect to international and GM regulation, there are no solid legal barriers yet to de-extinction, but you never know what might come down the road.
We'll take questions for all three of these speakers at the end of this panel. Is that Kansas, Andrew?
Oh yeah, right outside my door.
There's no need to rub it in, Hank. All right, I'm going low tech. Is this working? Yeah, great. All right, so thank you all for coming. I'm so glad we were able to get such an interesting group of and thoughtful group of people together to come speak on this topic. I did want to say at the outset that as the director of the UCI Law Center for Land, Environment, and Natural Resources, that I wanted to thank Stanford and Hank in particular for all the challenging logistical work. It really, I think it's, aside from a couple AV issues, it's gone really well. For the panel, I'm really going to focus on a number of U.S. federal environmental legal issues that are raised by de-extinction, and only briefly discuss its relationship with the concurrent state regimes. And my hope is that Chuck will talk about that to a certain, at least with regard to California, as well as other issues. Let me start with, I guess, my conclusion. As I think hopefully will become apparent from my brief discussion, I think that in general, the existing regulatory regimes focus on protecting existing endangered species, on minimizing human development, rather than promoting, in general, and repairing habitat, at least with regard to endangered species, and on either historic preservation of existing landscapes or, alternatively, in some areas, protecting and maintaining wild, untrammeled land. That in general, this doesn't map particularly well with the possible revival of extinct species. And that's not particularly surprising, given that it wasn't designed with de-extinction in mind. But it nonetheless makes, especially the introduction of most revived species, a challenge under existing federal U.S. law. That being said, and even though I think de-extinction's value for conservation still remains to be debated, I don't think it should be categorically rejected or dismissed. I think, as with other conservation strategies that I've written and talked about, ultimately I think de-extinction really reinforces the need to reformulate natural resource management more generally, to try to make risk assessment and adaptive management the foundation of natural resource law. So, okay, let me explain this a little more fully. And I'll spend more of my time talking about sort of descriptive questions of what does the law allow and not allow, and hopefully have some of the normative parts carry out for the rest of the day. So the existing federal environmental framework is implicated at generally two distinct regulatory moments. The revival stage and introduction to some sort of environment. And the most directly applicable U.S. law at each of these stages is, perhaps unsurprisingly, the Federal Endangered Species Act. But I think once again, I'm going to start with a conclusion. I think once we talk a little bit about the different provisions of the Act, you'll see that the existing ESA really is not particularly well fitted for providing a comprehensive framework for de-extinction for each of these different regulatory moments, both revival and introduction. So under the existing Endangered Species Act, shortly after revival of some sort of organism, a species could potentially be listed as endangered. But a range of issues are raised about this beyond the typical scientific and political questions that many of you who are familiar with the Endangered Species Act know are typically raised in the listing process. The first question, it would perhaps be, is this the same species? Of course, what's a species is contested ecologically, as Beth mentioned earlier. But though it may seem strange to some, for this purpose, it's actually not a scientific question, but a legal question. And the Endangered Species Act relies on a pretty liberal definition of species that initially seems to focus on the capacity for interbreeding, but expressly treats, quote, distinct population segments, end quote, as a separately protected entity. So whether it can breed with other population segments or not, we actually confer protection on distinct population segments of or subspecies. So how would this definition apply to de-extinction through selective breeding or cloning or genomic editing? So there might be legitimate scientific questions regarding whether a revived organism would be considered a new species or not. But I think legally, I think based on this definition, I can talk about it more later, any revival would quite likely be considered a distinct population segment from any existing species. So I think it quite clearly would qualify as a species. But then the second question is whether it's an endangered species. And again, that might actually seem like the easier question, right? Certainly you've got one organism or two or three, certainly strikes perhaps that it would be obviously endangered. But the Endangered Species Act actually defines endangered as in danger of extinction throughout all or a significant portion of its range. And the question obviously would come, for at least some revived species, is if it's captive, revived, what is its range? Does it have a range? It has no existing range, presumably if you have one organism sitting in a lab. On the other hand, the Endangered Species Act, in talking about in listing what are the factors for considering in order to determine whether it should be listed or not, does include some factors that suggest listing would be appropriate. For example, are there natural or man-made factors affecting its continued existence? I think that's a pretty likely, certainly there are man-made factors that would affect the existence of a species that only had one organism sitting in a lab. Questions about are existing regulatory mechanisms inadequate? Is it overutilized or utilized for recreational, scientific, or educational purposes? Depending on how these factors are interpreted in this particular context, it certainly could be construed as being endangered. Now, interestingly, the Endangered Species Act includes a process for relisting extinct species to endangered. Right? This process has been used before for a number of species that were thought extinct, but based on new information, determined that in fact it isn't extinct. It is actually endangered or vulnerable of some sort. But I think nonetheless, it's fairly clear that the Endangered Species Act did not contemplate revival of extinct species in setting up its regulatory infrastructure. right, so assuming that a species would be listed as endangered, presumably, I mean, the Endangered Species Act includes quite a few number of broad prohibitions, and if once listed, revival activities may be subject to a number of these broad prohibitions. The most notable being the prohibition on any take, which would include any sort of harm to the species, any sort of transport or sale of the species, unless there was some sort of permitted exception. And the most likely exception that would potentially be used for revival acts, I think, are quite clearly the captive bred wildlife regulations, because they seem the most analogous. I mean, these provide a federal permitting process for certain endangered wildlife which are bred in captivity. But these also provide some interesting distinctions that are likely to affect the future of de-extinction. The first of these is that they only apply to wildlife, not to plants, right? So the Endangered Species Act, many of you may know, restricts human activities pertaining to endangered plants, but not nearly as restrictively as it does for animals. So for plants, there are certain avenues for permitting of activities. I think the most likely scenario would be for scientific purposes or enhancement of propagation or survival. There are some provisions regarding endangered plants that might apply. But so even though we think there might be a close analog, it doesn't apply. This is analog of captive bred regulations. Doesn't really, captive bred wildlife regulations wouldn't apply to plants. Second, I think it's worthwhile noting that these generally can only be granted for conservation purposes, to enhance the propagation or survival of the species. So it bears mentioning that that the Endangered Species Act would prohibit activities that were not for conservation purposes for a listed species. Finally, and perhaps most importantly, and perhaps anachronistically to some, they're primarily, these captive bred wildlife permits are primarily for exotic species, for species whose natural geographic distribution is outside of the United States. The only exception is if the Fish and Wildlife Service director determines that the species is eligible, because essentially that wild populations are effectively protected from unauthorized taking. All other native species are subject to the Endangered Species Act's take prohibition. So the criteria for captive breeding requires the species to be either exotic or well protected in the wild. And again, when you're talking about a revived species, what is it? I think it's fairly obviously so that they would not be well protected in the wild. So it makes a revival program for native species particularly difficult. Now, a different, arguably conflicting set of provisions and questions apply regarding the introduction of any revived species. So I talked about revival, then what about introduction? As Hank mentioned, at a different stage of the process. I think most revivalists consider it important that any revived species be introduced on reserved lands. But of course, there's a suite of laws that apply for introduction onto those sorts of lands. And we might expect or hope that the decisions on introductions will be based on some sort of risk analysis, right? Where that considers the benefits of introduction and the risks of it. But actually, in the United States, it's primarily anchored in who's doing the activity, what type of species it is, and what kind of land would it be introduced to, with perhaps anachronistic results. So the Endangered Species Act allows reintroduction of endangered species through a permitting process. But existing regulations make it a key question whether the proposed introduction is considered native or not. And the Fish and Wildlife Service has interpreted its authority to allow introductions outside of their native range only if the species' habitat has been irreversibly altered or destroyed. And the Fish and Wildlife Service has been very reluctant to allow this. In the 40 years of the existence of the ESA, there's only been 2 cases where they've allowed for the species to be introduced outside of its native range. And both of those cases, the red wolf in the coastal Carolina Islands and the Guam rail, were intended to be temporary translocations. So they were moved outside of their native range, but the idea was to bring them back. One of them was brought back, and the other one they're still waiting, the Guam rail, theoretically. So this really reflects a general aversion in U.S. natural resource law to aggressive introduction of species to new areas and the crossing of this native-non-native divide. But de-extinction really raises a couple of problems regarding nativity. right? First of all, whether a species would be considered native would hinge on if the revived organism is considered a different species than previously extinct species. If it's a new species, what is its historic range? It has no historic range if it's a new species. If it's not, if it's considered some sort of hybrid of a pre-existing species, it's unclear what the range would be for that revived species. In the past, the baseline for historic range has generally been right before European settlement, so pre-Columbian settlement. But for some species, the mammoth, an obvious example, this baseline might provide, again, no historic range. But very few historic species would have a range based on that baseline. So what would its range be? It's not quite clear. So I think there's a strong argument that it would be considered non-native in a lot of places that it might be considered to be introduced. Second, and it's a related question, it also hinges on the particular agency or land's definition of invasive, which it vary considerably from jurisdiction to jurisdiction, even within the United States. So if it was deemed invasive, any kind of determination listing of a species being invasive would obviously have significant barriers for introduction. Now, some jurisdictions do require a species to be deemed to be harmful in order for it to be invasive, and they define harmful differently. But some jurisdictions define invasive as non-native. And some define non-native as either naturally not occurring, or some define it as actually introduced by humans. If it is introduced by a human, it is non-native, and therefore invasive. Okay? So this obviously would make revival in those jurisdictions quite difficult. I think another complexity is the type of land that it would be introduced into. I think Chuck is probably going to speak about state, or could speak about state lands. I won't prejudge what he's going to say. But for private parties on private lands, it's relatively easier, particularly if it's a plant. But even if it's wildlife, it's the only provisions that apply, which are still barriers, but less so, are the ESA's Section 10J reintroduction permits that I mentioned before. But on federal lands, which is important to note, about 30% of all lands in the United States are federal lands, and even a higher proportion of our natural or sort of reserve lands are federal lands. There are considerable differences regarding introducing species. So some, like the National Forest or BLM lands, focus on promoting resource use and maintaining ecological function. Those kinds of lands would be more amenable to introductions in general. Other lands, like national parks, focus on preservation and restoration. And these lands might be amenable to restoring recently extinct native species, but not others. And lands like federal wilderness, which primarily focus on maintaining wild, unmanaged areas, would be particularly barriers for any kind of introduction. So whether an introduction could be allowed largely depends on the particular goal of the federal land. All right, so I think there are a number of barriers and distinctions made in existing natural resource laws that may make little sense when mapped onto de-extinction. I think these various different distinctions make, especially the introduction of most revived species within the United States, a challenge under existing law. Now, I'll conclude with saying that I don't think that the answer then is that de-extinction should necessarily be categorically dismissed. I think what de-extinction does, it reinforces this problem in American natural resource law that I think exists more generally. And I'll conclude with 3 thoughts that are raised by de-extinction for U.S. natural resource management. The first one being, why tether management goals to a focus on maintaining the past? I mean, even though we know ecosystems evolve, and they always have evolved, and they'll continue to evolve more rapidly, particularly in the context of climate change, why not look for management strategies, like introductions even, that promote favorable conditions today? Now, those would be contested questions, but rather than focusing on a historic baseline or keeping things wild, we might want to think about promoting ecological function as the primary goal. Second one, quickly, why not build risk assessment and adaptive management into analysis rather than a fidelity to simplistic dichotomies like native and non-native or natural and artifactual? Those might be important distinctions, but less significant than the primary risk assessment and adaptive management. I think that should be the core. And third, we shouldn't rely on a fragmented regulatory regime where different jurisdictions define things differently and have different goals that are at cross purposes with each other when we know these species and ecosystems do evolve. All right, so I'll finish that and hope to hear from the rest of you. Thanks.
Two tough acts to follow. Let me grab a bottle of water.
That we've got. Slow check water.
Well, I'm going to go old school on the presentation here. And I'm actually thankful for traffic this morning. I live in Berkeley. So I put the finishing touches on what I might say in some of the traffic I found coming through town. Gave me an extra moment. How's everybody doing? Ready? Okay, I'm not exactly sure what I'm going to end up talking about. But I want to start by thanking Alex for the invitation, Hank for the organizing of the event. My name's Chuck Bonham. I have the great pleasure of being the director of the California Department of Fish and Wildlife. I'm coming late to this topic. I feel like a newbie to a dialogue many of you have been having for a while. I don't have an argument. I don't have a case to make. What I do have is a personal plea to most of you in the room. I've taken the last couple of weeks and seen all of your TED Talks, looked at your meeting minutes from the National Geographic session, seen those points that most of you perhaps have found most consensus on, and want to speak from the heart and move this into a practical discussion. But before doing that, I got to get a caveat established, both here in the room and anyone that may be watching it in the future. So despite my job title, I'm here today as me, Chuck Bonham. I'm not speaking on behalf of the Department of Fish and Wildlife, certainly not this administration or the governor, and definitely not the state of California. So could we pause for a minute? Just let me see everybody nod their head. Stewart, I didn't see you nod. Okay. All right, so with that, what I want to do is I want to introduce to you, because I think in the room are some of the few individuals who may drive this to practice in the field. And I want to introduce to you wildlife agencies, and I want to share with you, and at the end of the conversation, I hope that I've left you with a sense of sympathy, if not empathy, for how your work may relate to what we're doing. So to get there, let me tell you a little bit just about our department, give you a sense of practice. We've been around almost 150 years in some form. We started in 1874, I think, as a board of fish commissioners. We have an annual operating budget, give or take, about $400 million a year. We have about 2,500 employees. We're both highly centralized in Sacramento with subject matter expertise like our law, our legislative, our politics, our administrative functions, but equally decentralized. We divide this great state into 7 regions. Each region has a regional manager and a suite of administrative and scientific folks out on the ground. We manage the second largest amount of land in the state behind our state park system. We've got about 1 million acres in ownership or management. And while it's urban myth, and it's perhaps something, if I had known before I said yes to the offer, I might have said no. We're actually the second biggest licensing and permitting entity in this state behind our Department of Motor Vehicles. So you actually can't do much in the state of California without at some moment needing an approval from our department. Our mission. Our mission is to manage, and for me, manage really does relate back to the presentation Dr. Temple gave, the 3 stools of conservation, which are to protect, conserve, and restore. So we manage this state's plants and animals and the habitats they depend upon for their ecological value and their use and enjoyment by Californians. We take that mission and we translate it into one word, in my mind, stewardship. We view stewardship as a duty, and it's a duty that runs in perpetuity. Okay? So with that, I come to my first story, and it's a fish story. So about a year ago, I was judging a photo contest on the state capitol stairs, and I got to pick the winning photo of wildlife action shots on state lands. And the winning photo, a gentleman took a shot at Clear Lake. Clear Lake's about an hour and a half north of San Francisco, not in the coastal zone, not in the Central Valley, large lake. And the first photo he took was of a bird, I think a falcon, coming into the lake, capturing a fish and flying off. He thought that was cool. Next shot, another bird comes into the frame. Winning shot, one bird with its talons in the tail flying one direction, another bird with its talons in the head flying the opposite direction. And I thought, that's like life at our department. And when you think about that, it's actually a reflection of the facts. So those facts have an immense scope and scale. We're responsible for about 160,000 square miles. That's about 30,000 miles of rivers and streams, almost 5,000 lakes, about 1,100 miles of coastline, 3 miles offshore, all the critters swimming in the ocean in that zone. The highest spot in the 48, the lowest spot, the Coast Range, the Sierras, the Cascades, about 6,700 species, which if you break it down is 197 mammals, 433 birds, 84 reptiles, 67 freshwater fish species, and 5,047 plant species, which means we have more biodiversity than any state in the union. We actually have the largest number of species at risk. We're the second behind Hawaii as the number of endangered species living in a state. And we actually lead a list which is proving to be both exciting and frustrating. We have the highest number of one-ofs. One of this or one of that. And I don't mean one literally, but a few numbers. So I give you this description as context because I think the context is important for you to understand when we run into the question of de-extinction. And as a director, I'm the first director from outside this department in a long time, from outside state government maybe ever, and the youngest. So let's add to this context climate change. So this is a list I do not like. We're second in the nation in loss of biodiversity. And when you add salmon runs to that, we go to the top of the line. And just this morning, the University of California, Davis, Dr. Peter Moyle, pretty well-known fishery biologist, released a report that said of the 120 native fish species and the 50 that are non-native, they predict 82% of those will be extinct in the next 100 years because of a warming climate. Okay, so that's how I get to the question of what do we do with de-extinction? On one hand, we have this responsibility that we think runs into perpetuity. We have this amazing diversity in this state, and we know we face an increasing biodiversity catastrophe here in California. So what did I do? When I got the invitation from Alex, I polled our staff, and they're mixed, like I'm mixed. All at once, collectively or individually, we're scared, we're worried, we're thrilled, we're excited, we're upset, we're angry at you in part for exploring this idea, but we also think we may not have any other option at the end of the day. You've heard a lot of the topics raised with questions like, why would you do this? Does time matter? What about the things that are there now? What about the habitat? Will it have the carrying capacity? So on and so forth. I'll tell you an area that gets very confusing for us, and that is de-extinction may look a lot like some of our current work. Let me give you a few examples. We just won a case, Paiute cutthroat trout. It's a small stream in the Sierras. It's the most rare and endemic fish in the United States, trout species. We've gotten permission finally to go chemically sterilize a stream, remove non-natives, let the macrovertebrates rebuild, and then reintroduce a strain of Paiute cutthroat trout. Now, it's not an extinct species, but it hasn't been in that geography for quite some time. We've brought condors back from the brink of extinction because of captive breeding. One of my senior staff that I polled told me he became a biologist in 1973, the same year the ESA was authorized. At that time, there were 6 pairs of peregrine falcons breeding in California. Now there are more than 200 pairs because, quote, we manipulated their reproductive success through artificial breeding techniques and managed everything from incubation to fledgling. That starts to look a lot like some of the things you're discussing in the context of de-extinction. So this ambiguity, this closeness in practice scares us because we don't know what to do. Let me turn to wildlife law, seeing that my time is running short, and I want to leave you with an impression of what that law looks like at the state level. So way back when, maybe the Greeks, wildlife had a revered status. I'm told you move into the Roman era and wildlife began to be viewed more as property, perhaps. You move into the English law period and we see for the first time an attempt to regulate the practice of the hunt. And then that law transports to America, yet America at the moment that transport happens is abundant. It's full of species wealth. And there's less class diversification in those who are in America at that time, and hunting is a way of life. So you see a rejection of that idea of regulating wildlife at the beginning of America. But over time, as the populations dwindle, you see some concepts emerge. And those emerging concepts are, how do we create sustainability? How do we regulate personal activity through the management of hunting as an exercise? And how do we ensure the right of wildlife to exist? So here you run into state wildlife law. You see it show up in the United States Supreme Court cases in the 1840s around oysters, McCready versus Virginia. Then you see it show up in the later 1800s around game bird management in a case called Gear versus Connecticut. And you see states start to exert this idea of state ownership, wildlife being the property of states, not in the context of a possessory interest, but rather the management of them for sustainability over time. Of course, you had federal law like the Lacey Act, I think in 1900, already on the scene. And since then, you've had federal law emerge. But here's how I think it works at a state level. We tend to see in each state some memorialization of the idea of wildlife for the benefit of a state's citizens in a constitution. Then we tend to have, in some states, both some sort of commission and some sort of administrative agency like mine. And in our state, we have both. Then you tend to see over a period of time code and regulation, and then enforcement around those codes and regulations. And let me walk you through an actual code, which I want you to leave here thinking about. I pulled it. It's our Title 14 of Code of Regulations 671. So those of you, and I just assume at some point we'll be doing de-extinction. It was a consensus comment in your National Geographic meeting minutes. I think you rounded a corner and concluded this may happen. And we ought to be discussing how it should happen. So, Code 671. It shall be unlawful to import, transport, or possess live animals restricted in this subsection. Then there's a long list. Code 670.7. The department may issue revocable permits to take fully protected species for scientific purposes. Those permits may be only issued to members of faculty or professional staff of a scientific or educational institution. Then we go on in this code section, and we see permits for restricted species, 671.1. It is unlawful for any person to import, export, transport, maintain, sell, dispose of, or use for any purpose any animal restricted in the code. Let's go on from there. Same code section. And Hank is holding up his sign. I can see out of the corner of my eye. Release of animals into the wild, 671.6. No person shall release into the wild without written permission of the commission any wild animal that, quote, is not native to California, is found to be diseased, may be genetically detrimental to native wildlife, has not been successfully introduced prior to 1955, or ... So what's my point here? My point is, soon, you need to stop thinking about the theory of this and start worrying about the practice of this. My expectation would be subsequent regulation, possible legislation. I can contemplate regimes such as our department becoming an entity which would license, inspect, and certify facilities, subject only to the facilities having genetic management plans, reintroduction strategies on timelines, and an intensive negotiation in order for us to eventually permit that first release of the passenger pigeon in California. We don't have that body of law yet. Okay, I'm going to take a liberty and just say that I've got a toddler at home, and I've run across someone I think who is the most brilliant, one of the most brilliant writers we've ever had, Dr. Seuss. And Dr. Seuss told us, if I can find my notes, think left, think right, think low, think high. Oh, the things you can think up if you only try. I ran across Albert Einstein talking about, I think, imagination, who said, imagination is more important than knowledge, for knowledge is limited to all we know now and understand, while imagination embraces the entire world and all there ever will be to know and understand. I think much of what you're doing is driven by that quote from Dr. Seuss and that spirit of imagination. We may need this tool, but here's my plea to you, and I'd like to get some eye contact because this is a pretty personal plea. I think we need a social compact almost between our side of the house, the regulator community, and your side of the house, the scientific innovation practitioner side of the family in conservation. We're going to have to go through this together. We need you, I think, to build into your narrative and your messaging how important it is to hold on to what we have and prevent extinction, just as much as you need to advance your narrative. We may be able to revive and bring back those things we've lost. Let's not fall into a zero-sum game. Let's do this together if, in fact, we're going to do it. Thanks.
Andrew, Alex, Camacho, open for questions. Come down to the microphones for questions. And since I happen to very strategically situate myself close to a microphone, I'll take the first question. So let's assume it's 2018 and at a lab someplace in California that is licensed appropriately for the materials it's using, someone manages to produce the first sort of revived passenger pigeon. It's not genomically exactly identical to sequenced from any of the passenger pigeons that we sequenced, but it's pretty close. We think that most of the genes, most of the exons, most of the protein coding regions in the genome where the bandtail pigeon that they started with have been successfully transformed into gene sequences from the passenger pigeon. And this little chick pops out of the egg and manages to survive without asking for a legal opinion from some of you who may not be licensed to practice law in this jurisdiction and wouldn't want to give a legal opinion anyway, even if you were.
Without a retainer, at least.
Yeah. Boy, the UCI Law School is really off to a great start. You're teaching your students well. Does that birth, do you think, do anything illegal? And I'm assuming, by the way, since it's not, I think it's a GMO. It's a genetically modified organism that's not entirely, genomically at least, the passenger pigeon or the band-tail pigeon. Is it illegal under anything that you know about?
It's not really transgenic. Those are all pigeon genes we're talking about.
Yeah, but they're genes from different species of pigeons.
That's a GMO question. I don't know.
But
I'm leaving it to you.
Andrew?
I think the more commercial it is, the more likely that it is regulable. Whether or not it's illegal or not, I don't know.
Why?
Well, because the more commercial it is, the more able regulatory agencies are to put their claws into the issue and cite statutes that they can apply, cite existing regulatory frameworks that they think they can slot it into. Yeah. To the extent that it's simply a non-commercial pastime, somebody does
research
or research, where it doesn't implicate commerce as much, I think it's less likely that it will be considered either illegal or regulated.
Yeah. I mean, we make GMOs all the time in the lab.
Yeah.
Make GMO mice all the time in the lab for various medical research. And that apparently doesn't implicate the GMO process.
Well, in fact, there's a genetically engineered organisms Olympics that takes place at MIT every year in the fall. And I'm not saying that it doesn't implicate law, but there are teams from all over the world that come to MIT to report on genetically modified organisms that they've made not in well-regulated laboratories, sometimes in their kitchen sinks.
And Chuck?
Not answering the legality question.
Yeah.
My approach to your question would be to encourage us to not wait until that moment. Let's use the time frame between now and then. If this is going to happen again, my assumption is the discussion is based on that predicate. So if it's going to happen, let's design a regulatory approach before we arrive at that moment. We have all kinds of things to sort out, just starting with core language. Most of our wildlife law uses language, as Alex referenced, that has words such as invasive, non-native, game. Those are all words, both for our general public and our law, we're going to need to sort through together if this is where we're headed.
And really, the reason I asked the question that way is I keep getting drawn to this distinction between the initial creation and the release. And it does, with the captive breeding herd or flock in between, it does seem to me from what you guys have said that the release is certainly raises much bigger legal issues, but potentially even the creation in a lab setting could raise legal issues.
Yes, we regulate now in our state through that 671 suite of code regulations I described, all kinds of exotic, and I use that word as it's defined in the body of law, species facilities.
Yeah.
Some of which are just home, some of which are producing.
So Beth's lab might become an exotic species facility.
Well, it's certainly true that labs are regulated, right? I mean, they're regulated through all sorts of different things. So yeah,
that's right.
I mean,
Stewart.
Hi, Stewart Brand, Revive and Restore. Chuck, I wish we had a species we were trying to bring back in California. It'd be fun to work with you on this. Actually, we'll probably, in terms of the passenger pigeon, be initially working in Ohio because the Cincinnati Zoo is interested in helping with the captive breeding and eventual potential release there. So my question is, how much do the various state fish and game and wildlife organizations relate to one another? Are you guys all totally separate entities who never talk? And what's your relation to the feds?
Well, like in most of life, that's a complicated question. And you have the benefit of having a twofer in one of the subsequent panels. Ms. Clark used to be the director of the United States Fish and Wildlife Service, so
Great.
I encourage you to chat with her. But in my experience, each of the 50 states, it's its own sovereign, but we're all members of associations and coordinate regularly. You'll see a difference of opinion, particularly. California tends to be on the more progressive end, and we'll see things differently perhaps than some of our Intermountain West states. And all of us have our unique relationships to the federal government. I will say, though, Stewart, what I need from y'all and just the community at large is to figure out that filtering process, to figure out which you might like to push for de-extinction. So I'll just use our state flag. Grizzly bears on our state flag.
Only grizzly bear in California.
And that state flag, I think, is based on the last one captured by a reporter at the behest of William Hearst in 1889.
Monarch, he was called. I've petted the stuffed bear.
Do we bring them back? I got the same thing in the Delta. You know, if you're paying attention in California, you know that we probably got the nation's toughest water dispute and long-term infrastructure debate going on about the future of one of the West Coast's most important estuaries. And it was only a couple of years ago that we lost the thick-tailed chub in the Central Valley Delta. Do I bring that back knowing I have an extremely litigious world right now just around the management of the existing species and the industry that would be an opponent to the idea of bringing back yet another federally or state protected? So what I'm pleading for is using this space now to figure out, if you're going to go here, how we might do it.
How do you relate to migratory animals? So you got the flyway on the West Coast. It goes up to Oregon, to Washington, and Canada, down to Mexico.
Yeah.
Do you guys coordinate on animals that cross those boundaries without permission?
So Alex, I think, is an expert here, Jamie, but migration triggers the Commerce Clause in the extent that you see a major part of wildlife law on the federal front being done either through federal land ownership, rationale, treaty rationale, or Commerce Clause. Migration means you're crossing state boundaries. I think we do reasonably well coordinating between state and federal on salmon, which is highly migratory, and on the Pacific Flyway.
Great. So having precedence helps, it sounds like. Yeah.
So I'm brand new to this, but there were a couple of examples that I've worked on over the years that struck me as extremely relevant. And one of these examples is, I think, relevant to what you talked about, Andrew, and that is the genetically modified salmon that's about to be, I think everybody thinks is about to be approved by the FDA. Yeah. And it's interesting for a couple of reasons. One, this issue of the applicability of language. So they're regulating this genetically modified salmon not as a genetically modified organism as such, but they're regulating it because the process to modify the genes is treated by the FDA as an animal drug. Right. And so they're putting it through the animal drug approval process. So already that's a great example of the existing legal structure not fitting what science is doing. But and I think it's only regulated as an animal drug, incidentally, because people are going to eat it, right? So if people aren't going to eat the species, then the FDA's jurisdiction, I don't know if you would agree with this, probably doesn't matter. But what's interesting about it is, and I think this is what's relevant, is if you look at the approval of this animal drug, every facility that produces it has to be approved by the FDA, and FDA did an environmental assessment of what the effects of this might be. And in order to convince everybody that this genetically modified salmon would have no effects on wild salmon, the production of the genetically modified salmon is like out of James Bond, right? So the eggs are going to be produced in some facility in, I think, Labrador, where they're going to be hermetically sealed from any actual streams. And then, I'm not making this up, they're going to produce the adults in Panama, where they're going to be produced in some cold mountain regions in Panama, again, protected from the outside, but even if they escape from the outside, they'll be in cold mountain streams, but they'll be buffered from the rest of the world by the warm jungle habitat that you encounter as you go downstream. And and it wouldn't surprise you as you read this stuff that there'll be, in those lagoons or those streams, there'll be sharks with chainsaws on their heads. I'm curious if you thought about that example and how it fits. But the other thing that I'm struck by is in terms of the Endangered Species Act, what's going to be a huge issue is not so much how you define these de-extinct species, but what their effects are on the existing endangered species that we have. And if you've got a risk that this de-extinct, now brought back species is going to occupy habitat that's used by an existing listed species, and obviously the passenger pigeon example, none come to mind. I think that's really where the Endangered Species Act, you might have problems with reintroduction. And there's actually the other example I'm exposing I used to work with Chuck on fish issues, so I'm going to expose my fish background, is we've done this a little bit with salmon in that we've got these hatchery populations of salmon that have been so altered by their lives in the hatchery that the Fish and Wildlife Service and the National Marine Fisheries Service actually consider them genetically distinct from wild salmon. Mm-hmm. And there's a long history of tension between the use of these hatchery salmon to augment stocks of wild salmon and what to do about their interaction, positive and negative, with existing populations of native salmon. So in terms of this really wasn't a question, it was more of a comment, but I'd be really interested in the extent to which you've thought about this, the interaction between these not genetically modified through any technology, but just long practice in the hatchery fish and native fish, and how that might affect the introduction of de-extinct species.
Well, if I could,
yeah, go ahead.
I'll start and I'll leave the endangered stuff to you. I think that it's a perfect example, the way that this first generation of genetically modified salmon are being treated. It's a perfect example of how adaptable the law is. The law didn't have an obvious framework to put the salmon into, and so I'm sure that at some point somebody got together and said, okay, is it going to be you, EPA? I don't know. How about you, Fish and Wildlife? Is it going to be you, FDA? And the FDA finally, got the short end of the stick, and they said, okay, fine, we'll regulate it. How do we fit it into this incredibly complicated Food, Drug, and Cosmetics Act? Oh yeah, it's a drug. And they could have gone a number of different pathways even within the FDA. So I think in some ways we should be, comforted by the fact that the law will find some way to slot these new technologies into an existing framework. I think it's just a way station, though. I think that, first of all, I suspect the second generation of genetically modified salmon will not be as James Bondish. As people get more and more comfortable with them, I suspect they won't be in Panama. They'll be closer and closer to native habitats.
I should add, that's why people don't want it approved in the first place.
Well, exactly, because it opens the door. And I think this has often happened with biotechnologies. At first, they're treated as incredibly exotic and incredibly dangerous, and then gradually, especially the American public, becomes very, very comfortable with them to the extent that eventually they become less well-regulated. So I sort of predict that eventually these salmon will not have to go through all of the, what do you call them, chainsaw-headed sharks to get out. But now that's not to say that that's the right way to regulate them. I think that, and this was suggested, I think, by you, that there may be a much, much more appropriate way to regulate them, much more efficient, much more pinpointed, much more effective. And so we better start thinking about that now. Because right now the FDA is doing the heavy lifting. A lot of people think it's laughable that it is the FDA, but we need probably more appropriate ways to regulate these things. And I'm not saying that heavy regulation is a good idea versus light regulation. And in fact, I think part of what happened in the salmon case was not what the FDA mandated. It was what the company itself sensed they would have to do to get it through. And so I think company bent over backwards to reassure people. And this has been a very successful strategy in biotech. If laboratory researchers like the ASILOMAR folks, they detected an outrage growing, and they decided rather than be regulated from the outside, we're going to regulate ourselves quickly and do it as effectively as we can so that we avoid the heavy hand. And so I think that's also partly what's happening here. But as comfort levels grow and as specific legislation that is well tailored to the task comes online, I think that regulation will become it'll be easier, more commonplace.
So a couple thoughts. I mean, certainly the quarantining of experimental populations is very common with endangered species and captive breeding, et cetera. I mean, a lot of the regulations require that even species that are reintroduced, that they are kept outside of their native range, precisely because there's a concern that they will mix with the wild. So it's certainly there. I do think, similar to what Andrew's saying, that the law is adaptable, yes, but to a point. And I think part of what I was trying to make a point about the Endangered Species Act was that overall the driving factor for assessing a technology like de-extinction doesn't involve a risk assessment. decisions about whether to do it or not at a regulatory level in general are not framed in a way of what are the benefits of it, of an introduction, what are the harms of it. It's framed more as particular categories, et cetera. There often gets shoehorned a risk assessment, but it's not built into that. So I do think that the law is adaptable, but I don't think it's the framework that people would, I think most people would agree if they looked at the regulatory framework would say this is not a good one for de-extinction. Yeah. And the only other thing I was going to say was that I think your point about whether to about genetic modification in hatcheries and whether to include that the success of those populations and how it affects perceptions over the species in general. That is something that is coming up, and in the courts, it's still unresolved on a very concrete way. I mentioned distinct population segment as the frame for understanding an endangered species, and there's a dispute as to whether hatchery stocks can be included in the determination of whether a species needs to be listed or not. I think some courts say that a hatchery fish are a distinct population segment, and therefore each segment, the wild segment, gets protected, but others disagree with that. So I think it's still very much a dispute.
Let me take this law adaptable thought and just offer a view, and then give you a personal experience that happened about 2 weeks ago for me. And I'm enjoying the conversation. I look forward to the rest of the day. I agree that the law is adaptable, but I'm becoming more persuaded the current body of law may not be malleable enough to deal with climate change, apart from de-extinction. But let's just take de-extinction. So we have a state Endangered Species Act, like many states do. It more or less tracks the federal one. But our definition of endangered is threatened with extinction. How can you be extinct if you're always available for revival? Okay, so let me give you an example of why I think our current law may not be malleable enough. Just on climate change, I made a recommendation to our state commission after a year of scientific review or longer not to list the American pika. By the way, maybe one of the cutest critters on the planet, like Q Disney, it's in the Sierras, and we can see with predictive models, which we don't trust, which is part of the problem, that in the worst case scenarios, and these are envelope models, not micro-habitat models, they could see a shrinking of their habitat 100 years from now. But as of today, their population is abundant, well dispersed, and they appear to be existing just fine. How do I reconcile these things? I don't know if I have the current body of law to do that. And I think, in a practical sense, Stewart and others, going back to Hank's question, imagine that moment when you do release that pigeon or want to. I'm pretty sure under current law, that's a discretionary decision that will require some sort of state or federal approval, which in turn is going to require some huge environmental review documents, which in their own right are legendary for collateral attack and all kinds of litigious obstacles. So I go back to my plea. If you're going to do this, let's use the space in front of us now to sort out how to do it.
Overdue for a break, but you've been waiting very patiently. So a short question, and the hard part always is the
short answer.
Well, it's actually an extension, because I was going to raise the glowfish, which, as I recall, and you can correct me on this, California managed to prevent the sale of the fish that was genetically modified to be fluorescent. How did they do that? How did California do that?
I'd have to go refresh my memory. It wasn't during my tenure, but I think we had a strong interest in the legislature.
Yeah, and I think it ended up as a Fish and Game ruling de facto, which I support the ruling, but I think it's pretty dodgy law. I totally support the idea of sorting these issues out right now. I can leave that.
I know a little bit about the glowfish. I think it was banned, its sale was banned in 2002 in California. And I think that was actually a commission action as opposed to a department action. The commission voted to not allow it in California, although there was pretty good evidence that these suckers were not going to, I mean, they were tropical fish. They weren't going to survive in the streams of the Sierras or any other part of California. I don't think it's been legally challenged. They're still available in most states, but not in California.